I think recording has started. It's exactly 4 o'clock. DP, you're going to start the live. Should we start admitting people? Did we lose Ajay? Okay, great. Thank you very much, all of you, for joining in. We'll give few minutes for others to join. All right, I think we can get started. We're 1 minute past 4. Thank you very much for attending our monthly webinar on ILA, with ILA on POSH. And I'm happy and glad to be presenting it every month on month and discovering new aspects on the law. So it's the 10th year of the law, right? And we are still discovering it. We are still learning it, relearning it. And I think we want to continue this journey. Today, again, we have amazing speakers. So I'll be sharing my screen right now. Okay. I think you can see my screen. All right. So the topic is how confidentiality applies in IC proceedings, during IC proceedings, and after that. Of course, this is a learning series that we have been continuing to do, and this is our 3rd year that we have continued, and we have got multiple learnings out of it, and we are churning constantly and continuously. Thank you, ILA. Thank you, team, for helping us, Indian Lawyers Association. So I will give it to Madhura to explain what they do.
Thank you, Smita. So it is our absolute pleasure, I should say, to work alongside KelpHR for last 2.5, 3 years now in hosting this monthly session series on the POSH law. The work that Kelp has been doing is amazing. So my name is Madhura. I represent Indian Lawyers Association, ILA, a young and vibrant platform, a network of lawyers that was formed about 4 years ago by Mr. Navneet Chugh. So the concept of this organization is availing a platform for all legal professionals, lawyers to come together, share, educate each other, grow, network, and overall foster the concept of legal community. So we work in a model of having local chapters across India. We have about 75 chapters in different cities of the country. All these chapters, they add a local flavor to how ILA shapes in their own city. So we'll be very happy to invite all of you to join this network in your city, reach out to us, be a part of this dynamic organization, and help each other grow. Thank you, Smita.
Thank you, Madhura, and thank you very much for that introduction. I'm sure there are multiple lawyers who want to join this camaraderie and grow. Okay. A little bit about KelpHR. I'm the CEO and co-founder. My name is Smita Shetty Kapoor. I started this company in 2013. The idea of this company was when the POSH law came in, it seemed very complicated. And unfortunately, we were speaking to some people who use a lot of legal jargons, and trust me, as an HR person, it goes above my head many times. That's why it was important to simplify this whole concept. So KelpHR was born to help HR folks, organizations, employees who get impacted because of this law and simplify the whole aspect. So that is our vision. Our vision is to create happy, safe, and inclusive workplaces. We work in the space of prevention of sexual harassment at workplace, diversity, equity, inclusion, and mental health. And we are constantly and consciously working in this space. The idea is to create safe workplaces And I would want to share with you all that we have launched POSH Awards. This is one of its kind in India that we do. This is our 4th year, and we get nominations and we pick up 25 safe workplaces in India. So the nomination for this year is open. Please go ahead and look at what we are doing. You should be able to, get details of it, log on to our website and you'll get to know more. About me, I think I've explained, but I would like to share with y'all the details about our eminent guest we have. We have 3 amazing people, and I had an opportunity to speak to them a few days back, and I was so excited to be doing this conversation with them today. First is Gandha. She facilitates conflict resolution through dialogue and mediation in family, commercial, and workplace disputes. In the social sector, she offers her time to the cause of suicide prevention and gender justice. She's a POSH consultant and is serving on several internal committees and inquiries. Gandha is certified DEI and POSH trainer. She enjoys engaging in meaningful conversation by facilitating workshops, listening circles, and dialogue clubs. Gandha, I hope we qualify in those meaningful conversation today. I really want this to excite you too. So welcome.
Thank you. Most definitely, we do qualify. This conversation does qualify. Thank you.
Thank you. Thank you, Gandha. I also have Ajay Meherchandani with me. I hope he's back. He had connected. I can't see him right now, but I'll quickly introduce him too. Ajay Meherchandani pursued his Masters of Law degrees in Access to Justice from TIS, Mumbai, with a brief stint as an audit student of MA course in Sociology and Department of Sociology from University of Mumbai. He has been practiced sociology of law as a legal scholar. His primary research methodology involves phenomenology, and he's interested to study situations and intersections of power, institutions, gender through the lens of social theory and pedagogy. He has been a POSH trainer for government organizations, NGOs, private organizations. He runs a research think tank which focuses on a
Thank you so much, Smita. Yeah.
Ajay, thank you for coming in. I hope I have done justice to your introduction, because
Thank you so much.
while I understand gender audit, gender and sexuality work that you do, thank you very much. And we need scholars like you to help us do what we do.
Totally. Yeah. Thank you so much for inviting.
Thank you. I have another lovely person on this call, Pinak Mitra. He's an advocate practicing in Calcutta High Court and also the Supreme Court of India. He promised to take me to Supreme Court next time I'm around.
Sure. Absolutely.
His area of practice is criminal law, constitutional law, consumer law, medical legal issues, real estate law, family law, and matrimonial disputes, intellectual property, and economic offenses. Welcome, Pinak.
Thank you, Smita, so much for having me on this panel today.
Thank you, Pinak, and we are really looking forward for some amazing discussion with the 3 amazing people that we have on board. And the topic is also amazing, because if you look at the law is just given 1 paragraph on it. So we are going to get more out of it. So to start with, if you look at English language, what is confidentiality? It's a noun. It's a state of keeping or being secret or private. That is the English definition of confidentiality. Now, if you look at it from the legal aspect, it says confidentiality is in sexual harassment cases refers to a strict protection and privacy of sensitive information related to a particular incident, the individuals who are involved there, the entire process, the investigation process. It is an essential aspect of handling such cases to ensure the safety, well-being, and rights of the individuals affected. Now, that is what the definition of confidentiality is from sexual harassment perspective. Now, what does Act say? Act says that we prohibit disclosure of contents of the complaint, identity and address of the complainant, respondent, and witnesses, information pertaining to conciliation, inquiry proceedings, or recommendation that is coming out of ICC or LCC, whatever the case may be, and action that is taken by the employer and district officer. That is what the Act is prohibiting. Okay. Now, I would want to stop share and hear from the three panel members if they want to start saying something, or should I just jump on to my questions?
I think let's answer the questions that you have, then we can summarize and put forward our views. I think that would be better.
Awesome. Thank you. Thank you, Pinak, for that. So my first question is for Ajay, actually. Ajay, Section 16 of the Act states that confidentiality to be maintained from public and media. Do other colleagues and co-management fall within public? What is the definition of public?
Yeah. Am I audible specifically?
Yes.
Okay. So specifically to start with the Section 16 of the POSH Act, and I'll also sort of deliberate on the other two regulations, which are the UGC regulations and the All India Technical Education regulations. Now, coming back to Section 16, they do sort of require confidentiality with respect to only the ICC proceedings. So only the members of the ICC or the panel that is investigating are supposed to have the information of the case, be it from the witness side, the respondent or the complainant, and any kind of disclosure by the ICC members is technically illegal. I mean, I would read it theoretically as a researcher, it is sort of illegal, and no disclosure to the management, be it the head of the management, be it their senior colleagues as well of the management, is prima facie allowed under this act. So my submission basically is that they can't, the public, also the management and people involved within the employee association or anybody who is the employee comes under this act. So the ICC members themselves have to follow the confidentiality, and whoever has information of the said incident or of the said allegation has to sign the non-disclosure, and it can't come in any kind of information either by formal or informal communication with respect to any employee in the organization. And even if the employer happens to be the head of the said department. So giving the example of a workplace where it's an NGO, and if there's a complaint against an employee of the NGO and someone else, the head, the director of the NGO or the boss, basically, or the person who is handling the NGO administrative matters, can't be, the information can't be disclosed to them. So specifically, the ICC members have to take this into account, and no kind of disclosure has to be made to anybody with respect to the information given. Now, Section 16 also sort of prohibits or the addressal of the complaint with respect to the aggrieved woman, as is stated in the section, or as it's stated as the respondent or the witnesses. So witnesses from both the ends, be it from the complainant side or from the respondent side, they do come into this, and the recommendations has as well come into this specific Section 16. If you actually go into UGC regulations and the regulations by the All India Technical Education Council, now those are specifically related to the workplace, as is the university. Now, we generally don't really talk a lot about workplace, university being the workplace, but even within the POSH Act, the workplace has been defined as any sector, be it public or private or an unorganized sector. And there are specific regulations for the university regulations as well. So in a very brief way, I would say that yes, no kind of disclosure is allowed by the ICC members or by the said parties from both the ends to anybody apart from the designated people who are looking into the case. Yeah.
Thank you, Ajay. And you spoke something about NDA. You said that NDA should be executed. So my question to Pinak is, Pinak, do we need to execute separate NDAs from all the parties? What is your take on that?
So before I answer to your question, I would just like to sum up the law from where the concept of this disclosure is coming and confidentiality. So firstly, we find in section 228A of the Indian Penal Code, which relates to disclosure of the identity of a victim. But that section postulates that the victim of mainly sexual offenses like rape, her identity should not be disclosed. Secondly, we also find relevance in section 327, subsection 2 and 3 of the CRPC. That also again deals with the victim who is a rape victim, but not of, say, a sexual offense, a minor sexual offense, maybe um, stalking or, say, the offenses under section 354 of the Indian Penal Code. And then again in the POCSO Act, which is not relevant here. So from the statutes that we have, the concept of uh, confidentiality is, apart from the POSH Act, is with respect to graver offenses, with respect to human body and the woman is concerned. Okay. Now coming to the idea of confidentiality. So far as confidentiality is concerned, as stated in section 16 of the Act, confidentiality doesn't necessarily mean anonymity. In order to have a full-blown proceeding, it is necessary that both the complainant, the respondent are aware of each other. That has to be. Apart from that, the witnesses who are there, they are aware of what has happened by and between the complainant, the allegation. So there cannot be complete anonymity. There has to be recording of evidences. Even the recording can be also recorded in a CCTV or in a in-camera proceeding and everything. So there, the question of anonymity is ruled out. Now coming to the question of confidentiality and disclosure, I think so far as company, the Act is absolutely silent on that. Only the section which we have to interpret. So far as companies are concerned, in a private internal committee proceeding, it's better that the companies have this NDA executed, though as far as the legal binding of this NDA is something is a debatable topic, because NDA, what the company, the concern can do through its HR, make the employees aware of the POSH proceedings, number one, regarding how sensitive it is and as to how the law is flowing from the Indian Penal Code, from the CRPC, and the importance of that. Having said that, then make them execute the NDA so that it is kind of a binding effect which has on the witnesses or the employees who are participating in the proceeding concerned. And then if anyone violates that, then disciplinary action can be taken against that person later on also. So I think it can be done to, enforce them or make them a bit cautious about whether they should spell out the names of the victim or gossip about them later on. So in order to, restrict, it might be a preventive measure, I would say.
Thank you, Pinak. I remember, and I was telling you earlier also, I remember in one of the cases where people were refusing to sign NDA. And
Yes.
they were witnesses, okay? And they were like, I don't want to sign an NDA. But anyhow, I feel that if you are an employee of an organization, you anyway are covered under code of conduct where you cannot.
Yes.
So that is also there. This is an additional thing to ensure.
So if it is introduced in the POSH policy of the code of conduct of a company or a concern, then automatically that comes that they are bound to follow that.
Yeah, they are bound to follow. This actually acts as a
deterrent, you can say.
Absolutely, and telling them that they are further have to follow this NDA. So I think it's a very good practice, and we should continue doing that. Thank you for that one, Pinak. I would want to ask Gandha this. Gandha, what do you think about 5,000 penalty that is mentioned in the law if somebody violates confidentiality, breaches confidentiality?
So I'll answer that, Smita, but before that, I'll also just add to the point that was being talked about before this. And you're mentioning that, signing the NDA can be intimidating for some people. We are talking about, a workplace, and the workplace can have people at various levels and their comfort with a legal document is very different. It's first of all intimidating to be called as a witness. Then we, it's private, and it's like about a topic that's so taboo. And then we are telling them to sign a paper. So it is intimidating, and we don't want witnesses to get intimidated, not just by the respondent, but also, so just be more, use your discretion in terms of whether you really want to get it signed or no. Have a confidentiality provision in your policy. Every time you do a training, you include that in your training. And every witness, if you find that it's not appropriate, if they're willingly doing it, it's fine. If they're not doing it, explain it to them. Take the time, and perhaps after you have actually spoken to that person, he may or she may be willing to sign the NDA. So let's, the idea is to create that environment where that person is comfortable enough to share, and not really, looking at it just in terms of the procedure, but because, as Pinak said, enforcing them is really difficult. So actually it is a piece of paper. Unless and until the person understands his responsibility in terms of confidentiality. So more than the paperwork, our intention should be the comfort of the complainant, the witnesses, and even the respondent.
So
And
well said, Ganda. Absolutely, I agree with you.
Now coming to the fine amount. The fine amount is actually provided under the rules, the Sexual Harassment of Women at Workplace Rules 2013. The figure mentioned is 5,000, but there is a provision in section 17 of the Act which allows you to put the figure in your service rules. So it's not a final figure. That if your service rules provide something else, then you can change the figure, because 5,000, as is something that's not going to pinch anybody. But again, over here, I'd like to add that is what the law is. And if you don't have anything in writing, when the act happens, you cannot change the figure. Then it has to be maximum of 5,000 rupees, because the provision in writing has to be done before the act happens. So if you want to have it, you see that it cannot be retrospective. It has to be prospective. So basically it has to be written first, and then the act happens, and then you can, enforce it. If it's not written, 5,000 is what is applicable to you.
Okay, so Ganda, you're saying that it's a good idea to relook at your confidentiality clause in your policy and see if you would want to. I think there is also an option of not only penalty in money, but there could be other.
Yes, absolutely. So that's the other thing. First of all, this matter of confidentiality is we must understand is a matter of culture. Gossip is a matter of culture, and sometimes it also flows down from the leadership. What kind of information are you seeking? What are your leaders doing? Are they, receiving this information? Are they receiving such information respectfully? Are they forbidding people who are telling them? It's a matter of culture, And if you don't...
So well said, Ganda. Sorry, but yesterday I was in this conversation where we were talking to the leaders, we were talking to HR folks, that how you should not indulge in such conversation. And if somebody is coming up and talking about somebody's private personal life or about a particular impending case which is going on, just raise your hand and say, just cut it out there. I mean, we were actually feeding them words that this is how you can react, which actually is a very commonsensical, but sometimes I feel it does not come very easily to us. Yeah.
We indulge in such things, and that's what happens with the culture. It percolates. So frankly, more than the fine, we must look at it as a culture, not just confidentiality. The meaning of confidentiality is actually respecting the privacy, the seriousness of the matter, what kind of pain it can cause your colleagues, that's what you have to respect and not indulge. And that's a matter of culture. But yes, 5,000 is the amount if you don't have any other provision already in writing and announced to them, to the employees. But at the same time, culture is what you need to keep looking at.
So well said, Ganda. I think very importantly for an organization, and if we have HR folks, leaders present here, this is a very important point, that it's not only about stick situation, it's also about role modeling the right behaviors. So as leaders, as HR, we can talk about saying transparency, respect, and this and that. But if you are not modeling the right behavior, you're not going to get that culture. So we have to invest in the right behaviors, right? And this is important. Thank you for that. And I'm going to move to Pinak and ask him about during investigations, Pinak, and after the investigation, who keeps those paperwork? They say that it has to be securely kept. So is it the duty of the presiding officer to keep those papers? What do you think about it? How it should be maintained? And in today's world of e-world, so how should the documents be securely maintained?
See, I think first of all, I would like to relax your question a bit and make it more flexible, because it is not only the duty of the presiding officer, it's the duty of the entire IC, who is acting as a body, as a say quasi tribunal. Okay, to each and every member, see, the presiding officer is the first amongst the equals. Okay, but the entire IC has the job not only of say receiving the complaint from the complainant, then helping the complainant to draft, then having the statements recorded of the witnesses, then coming to a finding, preliminary finding, then final finding, then making a recommendation. So it's a long drawn process, right? And in that, the entire process, not only the PO, but all the members who are a part of the IC are taking part in that. So they conjointly have a duty, first of all, with respect to confidentiality, each and every member is equally responsible. Now, secondly, so far as maintaining the documents and the details of say each case, I would say, is concerned, now that depends on organization to organization and how the IC is in place in that organization. If in certain organizations, ICs are constituted on receipt of a complaint to some senior authorities, even in government organizations, they don't have it in place. Some private organizations might have a fixed office, a constituted designated body, which is the IC, which is functioning continuously. So that is one aspect which has to be looked into, number one. Number two, if it's a permanent body, though the members might change on retirement or any other, their tenure must be fixed. So it is the duty of that body to keep this confidential and maintain it for a certain period of time. So that in case, say, for example, there is an appeal, there is a provision that we can go to appeal, or if someone challenges the order of the appellate body before the higher forum, that is necessarily the High Court. So whether these documents which were recorded, the statements were recorded, and the entire file of the proceeding has to be kept. And that whether the organization chooses to do it electronically or manually, that is for the organization to decide. But I think it is on the entire body, the IC, and not upon the particular person who is maybe the chairperson of the IC to take care. And there should be rules in place depending on organization to organization. They can have their internal rules, they will conduct the proceeding, keeping in mind the guidelines, the frameworks which the Act has laid down, and also for their own betterment, they can prepare their own day-to-day working rules. Like, for example, when we have tribunals, which are not strictly bound by the CPC or the CRPC, they mostly believe in principles of natural justice, but they can take, and they can also have their own sort of procedure. So that can be done by the IC of an organization.
So Pinak, one very interesting question from what you just said, right? I think Anuradha has posted that question on chat and I found it just an extension of what you're saying. She's saying of a situation where an IC member, okay, is part of a particular case, and now this person has exited IC. Now, how much of limitation or how is she bound? Is there any binding for her to not speak about the case? How will that work?
Definitely, because this section, the issue of confidentiality, what we have in the statute, is not only applicable to the witnesses or the complainant or the respondent. It is equally applicable to the members, former members as well as present and future members, to all of them. So if they are privy to a proceeding, it is their bounden duty, keeping in mind the guidelines of the POSH Act, and they are bound to follow and adhere to the provisions.
Okay. So Pinak, I don't know if you would want to answer that question, or Gandha, or maybe Ajay also. See, now we are in 10 years of this law coming in, right? That almost three years we have to change and we have new IC. Now, if there has been a case with the previous IC, ideally what I tell them is pass on the entire documentation before you exit and to the new IC and move out, right? The earlier IC is very, very hesitant to do that, right? And they feel that, confidentiality could be breached in such situation because they were part of that investigation. And now new IC will get to know about what they had done and all that. Do you have an opinion about it? Or maybe Gandha, Ajay, if you all have any opinion about it?
I think so far as I am concerned, my view is that, see, it is a body which has been constituted. Its members might change, might retire, but the body should be there in place so far as the mandate of the act is concerned. Like in courts, we have judges coming and going, but the court remains. Similarly, if we consider the IC as a tribunal, the same thing should apply to the IC as well. In any organization which has a fixed IC in place, and which should have, and not constitute a IC once the hierarchy receives a complaint of sexual harassment.
Right.
There should be a fixed permanent body. The members might change.
Yes.
That is my take on the issue.
Thank you. Gandha, Ajay, do you have?
Gandha, please go on.
I would like to add one thing. See, the ultimate responsibility of maintaining the documents is also with the employer. We must understand the members of the IC will keep changing. During the process of the inquiry, the employer is not supposed to understand or get into the details of the inquiry. He is supposed to facilitate in terms of providing the space, providing them, whatever resources they may need to conduct it in a fair manner. But once it's over, obviously the recommendations and the findings go to the employer, and also as you said, the members change. There is, in fact, a provision that mandatorily every 3 years members need to change. You need to reconstitute. Now, if that happens, there needs to be a place where the documents are stored and everything is stored. The confidentiality provision that is there and your commitment is perpetual. It has nothing to do with the role. Even if your role changes, you leave the organization, you still have that obligation. You cannot change the organization, go to another organization and disclose the identities of the people there. And what happened? It never becomes gossip. That obligation, it continues to be there perpetually. Okay, so if you understand the concept of that obligation, then the question is, yes, you have to keep the records, and that's a separate issue. But whoever is the IC member, even if they get exposed to it, they will be, they will have an obligation for confidentiality. Another point that you mentioned was about judging the earlier committee. Whether we did questioning it or something like that. Once the inquiry is closed and within 90 days, if nobody has challenged it, what they think about it is really not important or relevant. So, yeah.
Yeah, thank you for that. I think you brought in important points, and we'll bear this in mind. Ajay, do you want to
Yes.
add something? Yeah.
Yeah, just coming back, I do agree with what Kanda and Pinak have said. Specifically, I'll go back to what Kanda had said about NDA and witnesses in a very brief way. Mostly in such cases, if you see, there are rarely that we find witnesses. So there are usually no witnesses to be found in most of the cases. And with respect to the NDA as well, it is almost an obligation of the person who is an employee in the organization to make sure that they sign the NDA, because that is a part of their duty. For example, if you are an HR employee and if you are being given that, if you're privy to the information about such a said matter, it is a obligation of the position that you have within the company. With respect to also say the employer itself. So after the investigation is done, it's the obligation of the employer within whatever position that they have to maintain those records and also be signing the NDA. So whoever is signing the NDA, even say in the university, a student says a witness, or in a NGO, whoever is the witness, they are obligated in by the very act of being placed in that organization to sign the NDA. Now coming back to I also sort of also answering one of the participants' question about the obligation of how to deal with certain cases where the employer or the manager wants to know about the case. It's absolute, according to me. The ICC members absolutely have been enshrined with this specific thing to not be talking about it till the matter is investigated, and then the recommendation has been given to the said specific employer, the said specific position, and then the matter is taken ahead with the employer. So it's absolute that how to deal with the said manager. Just tell them you are in the ICC and you can't do it. You are not supposed to do that. There's no other way to deal with this apart from that. Yeah, and I do agree with the points made by Pinak and Danda about the earlier. Yeah.
Thank you, Ajay. And Ajay, I have a question for you.
Yeah.
So what happens is, and what you mentioned about witnesses, there are times when a complainant would want to speak to witness during the inquiry. Okay, so the complainant wants to have a conversation, wants to maybe provide more input, wants to. So do you think that is a breach of confidentiality?
It depends on also the formation of the ICC and also the internal policy. Certainly it differs from companies. If you see the ICC members within educational institutions, it's a very different formation. They do not generally apply all the rules and regulations per se. But having said that, if it is in the need to know basis in a limited approach, yes, certainly it is not a confidentiality breach. Complainant if the complainant wants to speak to the witness, that would mean if it's in a limited knowledge capacity, whereas it will be different if there's the respondent wanting to speak to the witnesses of the complainant. So it will be like two different procedures. But if the complainant wants to speak to the witnesses there beforehand, only in the capacity of what is needed to be known in terms of accruing some kind of evidence that can be placed before the ICC. So if say there's some kind of evidence that the witness might have had where the complainant does not have it, yes, in that sense, it is no breach of confidentiality. Having said that, the ICC members need to be informed, and there has to be an NDA beforehand with the witnesses themselves and with the information given to the ICC. Yeah.
That's an interesting point, Ajay. And I must tell you about a particular situation where we had got an NDA signed from all the parties. And this was a discussion with the respondent, and respondent, when he got the notice of hearing and he said an NDA was attached to it, his first question was, I want to speak to my wife about it, and I want to speak to my lawyer about it. So is that a breach of confidentiality? Because as per our NDA, they cannot talk to anybody other than IC members. Okay. Now there is this person who is completely traumatized and wants to speak to at least his near kin, about it. So
Right.
what do you recommend in this space?
specifically stating if the conversation has been done with the ICC member in place, and if the ICC member allows them to speak to someone who they would want to, without the names or the identity attached of who the complainant is. So without disclosing the name, identity, and any kind of identity marker of the complainant itself, yes, that might be possible in a very limited to no manner. Probably the respondent would need a therapist, or they would need some therapy, or they would need to speak to someone about it. So they can talk about the case without disclosing the said person's contact, identity, etc., which does not make the complainant, which doesn't trouble the complainant or doesn't disclose anything that where the complainant will go through some problem because of that disclosure. So the disclosure has to be made in a form where the complainant itself is not troubled by it, where the identity is totally masked. Yeah.
All right. Thank you. Thank you so much, Ajay. And I'll come back to either Pinak or maybe Gandha or Ajay, you yourself can respond. Now, see, there are, there are organizations which are terminating people for sexual harassment. Or there are organizations who are letting go of people because of sexual harassment being proved against them. It could be a simple resignation, but this was because of sexual harassment case getting proved. Now, what happens to their background verification in the new organization? If it comes to the organization where they have been let go, and if the HR person shares that they have been let go because of sexual harassment, is it a breach of confidentiality? So, Pinak, Gandha.
See, first of all, if there is a background check from one organization to another, say from an employee from organization A is terminated or asked to leave in a more respectful manner, and he tenders his resignation and then applies for a job in company B or C, then automatically if the company B is concerned, that they might try and do a background check from company A. And the reason which company A can give is that he has been held guilty of misconduct, or say he crossed the line and so he was terminated as per the recommendations of the internal complaints committee. Only that much information can be shared, but not the details of the proceeding, because that has to be kept confidential at any cost. But I was just wondering, just moving aside from your question, just taking it a step ahead, as to what happens, say for example, an employee is terminated, an employee of a company A. He is terminated after the recommendations are made. But eventually he prefers an appeal before the higher forum. And there the appellate forum finds that he is not guilty. Then what happens in a situation like that? Will the company reinstate him, or what will be the consequences that follow upon the complainant and the respondent is something also we should think of, because usually companies terminate employees as soon as possible. Just because the IC has come to a finding does not necessarily mean that the respondent is guilty. He might have the verdict overturned by higher forums. So,
right, absolutely. Gandha, Ajay, do you all want to add to what Pinak is saying? I will just reserve my input.
So I completely agree with Pinak. I don't, the background verification. Now there are again two cases, Smita. One case is where the termination is blatant and you mention it on the it's a termination letter, it's a proper termination process, and you mention it that it's been done because, so that means the offense there, you have adequate amount of evidence to protect yourself in case you're going in appeal. Now, generally, that is not what happens, because evidence in such cases is not as blatant. It's difficult to prove it. It's more about circumstantial evidence and the witness statements and things like that. Then what the organization does, it gives the respondent the chance to leave on his own. They ask him to resign. And the relieving letter in that case does not mention anything about sexual. It's basically he wants to go for better prospects or for personal reasons, and you close it over there. In that case, if there is a call from the other side asking for a background verification, I don't think it is appropriate to share details of the proceeding, because the whole understanding between the respondent and the company was that you leave because we feel you are guilty. But as Pinak mentioned, there can be an appeal, and irrespective of the appeal, you are unsure of your own evidence. That is why you have followed that procedure. If you were very sure of the evidence and it was that blatant, you would have terminated him under the act itself. So I feel that the whole thing depends on your evidence. And there is another perspective where you don't terminate the employee, you give another kind of a penalty, and he resigns on his own after, say, 6 months or a year because he's not happy with the second penalty also. In that case, you've given him a chance to reform. And from your side, you have closed the matter again. So if there is a call after that, again, evidence is just enough for him to not be terminated, and that information should not be disclosed. In fact, HR should not have that information. If HR does not need to know, HR should also not have that information. So that's what I feel about this.
So what I understand from this is that if the organization has clearly terminated that person, then if the background verification calls come in, you could always say that this person was terminated for sexual harassment. But if they have taken resignation, then there is no way that they can make that comment. And then it puts you in a bad situation if you do that. So that is something that is clear. And I would want to either Gandha, you, Ajay, or Pinak, how many years have we to save this data? Okay, so is there a time limit to save this data that about the proceeding sheets and everything? Do we have a time limit for that?
Pinak, would you like to answer that, or should I go ahead?
Initially, I had thought that it should be, say, 3 years. That was my initial viewpoint, but then I deliberated on this, and I think, say, for example, so far as the employee is concerned, who has been held guilty of misconduct and is terminated, I think for that employee, the data should be preserved forever. For maybe when the entire management changes, say after 15 years, that employee might want to rejoin the particular company once again. It is possible. So keeping that in mind, if the company wants to keep those sorts of employees out of its employee base, then it's better that we have the data stored at least somewhere. And so far as the legal aspect is concerned, at least 3 years should be the minimum time for keeping the data, whether the respondent is held guilty or otherwise the complainant's allegation is found to be false, at least so that they can prefer an appeal and that can be tested before the appellate forum and so on and so forth. So minimum 3 years, I would say.
So you're recommending 3 years, but according to you, sexual harassment cases, I think you should preserve it forever, right?
Yes.
Yeah.
Sorry, I just lost the connection. I had a point on termination. Specifically, There are some organizations which do ask about a disclosure statement for a background verification check. Now, if the organization has terminated the employee specifically for a sexual harassment case, so if the termination is because of the harassment case, then in that sense, and if the organization B, that is employing this person again, they need to sort of disclose it, because the specific question asked by the organization B would be the question of whether they were terminated because of sexual harassment or a disciplinary proceedings on sexual harassment case or not. If the question is about something else, then that might differ. But there are certain organizations that do ask the applicants if there has been a disciplinary proceedings against them with respect to the nature of sexual harassment. And if they do, then I think the organization also has to keep it for 7 years at least. Yeah.
All right.
Sorry.
Thank you. No, thank you, Ajay. So 7 years is what Ajay is saying. Actually, HR records also, as I'm an HR person, we keep HR records after the person has exited, at least for 7 years. That's what we have been doing. But we came to a decision that sexual harassment cases details should be preserved forever, because a person can come back, and then if it is not there, we might just go ahead and hire that person if we don't have a background. In fact, I must tell you a very interesting case that I recently dealt with, where a person had sexually harassed, was a perpetrator. Okay, we had given an outcome to this particular person saying that he has to give an apology letter. We gave a warning letter and said that you will be watched. All right. And then what happened is the entire committee changed, and it's a very large organization. Entire committee changed. And for some reason, the handover of the documents didn't happen well. There is no database which is maintained. So the new presiding officer, of course, won't go case by case to see what are the names of the people. And 3-4 years later, same respondent was in question. Similar sexual harassment case got reported. Okay. And fortunately, one of the IC members remembered, or via they remembered that there was a case, and they went back and looked. And if that hadn't happened, then we would have taken this case in isolation. So I think a great lesson from this was that please maintain a database, okay, which the presiding officer should pass on, at least the name of the complainant, respondent, and witnesses, who were there, and what was like a gist of that case, like an Excel sheet or something, should be maintained. So the first step should be that if you get a complaint, just go through that database, because we're in 10th year. And this is, we need to have some kind of database management here. Okay. So I think there are so many questions on the chat. I can't even keep a tag of it. So I'm going to start asking those questions. I think Amulya has tried to respond to many of them. Let me try and go right on top. If anybody wants to quickly unmute also, I think we are okay with that. I think we are having a great discussion, but we'll be mindful of the time. So Anuradha's question, I think Amulya has responded. All right. If the complainant is asking to know the details of witnesses, this is Roma's question, details of witnesses and demanding audio video recording of the inquiry with them, but the witnesses are not comfortable with their details being shared, what should IC do? Good question, Roma, and I will make an attempt to respond to it, and other panel members can add in or give in their opinion. According to me, if the witness is not comfortable sharing their name, a witness can give their statement in anonymity. Okay, that right is available. And we can tell complainant that we will give you the witness statement, but we'll redact the name of the witnesses, and that can be used for this. There is no compulsion for IC to give an audio video recording, and they can say no to it. That's my input. Ajay, Pinak.
I agree with you, Smita. Absolutely.
Thank you.
Absolutely.
Yes.
Even if it was recorded, say it was recorded, then it can be reduced to typed copies and provided to the complainant. If she, say, later on wants to prefer an appeal or whatever, that can be done. But the names of the witnesses, if the witness is scared or wants it to be kept a secret, then it should not be disclosed to either the complainant or to the respondent.
Yes, absolutely. Generally, the threat is from the respondent because they're powerful people. Yes. I saw Roma asking from complainant perspective, but that can also happen. Okay.
Hi, Smita. Could I ask over here, please?
Yes, Suchitra, go ahead.
So we have ongoing where the witness is scared, doesn't wants to be anonymous, but the complainant has insisted that she would like to cross-examine this person. Okay, and we are in a we are thinking how to do it. Maybe have it virtually, where her voice is there and we are present. Two of us are present with the witness and two of us are present with the complainant. Is that okay by law? Because we are not going to disclose the name of the witness, but the witness is going to say something where the complainant is going to understand who that person is.
I can answer to that. Say, for example, if then in such a scenario, keeping the name of the witness aside, say, let us assume that the witness is X. Okay, his or her statement in typed version can be provided to the complainant. And the complainant can then prepare a questionnaire and give it to the IC for laying it before the witness, and the witness can answer that and provide it back. It will be in the form of a cross-examination in question forms. So that can solve the problem very easily.
Perfect. Suchitra, I think it's a brilliant solution. I think this is what you should push for, that don't get them on audio, video, because by voice also some, it is possible for people to recognize some accent that they use. It's possible to recognize. Very difficult to maintain the anonymity. I think the best way, and we have done it multiple times, cross can be done via questionnaire.
Yeah. Thanks a lot. Thanks.
Thank you, Suchitra. There's one question from Amrita Sarkar here. She says, lovely session. Thank you, Amrita. Just wondering to know how LGBTQI people can get the benefit of this particular law, since based on their identity, either hidden or out, they get harassed at the workplace. Thanks. So Amrita, this is my favorite topic, so I would want to pick this up. So trans women are covered under this act. And unfortunately, no other, I mean, if even LGBTQI folks, if they identify themselves as women, then they can use the law. But unfortunately, if they don't identify themselves as women, then if they are in a workplace, there is a grievance handling committee which will be available and they can complain there. I'm actually having a similar situation where there is a trans woman, but unfortunately, they don't have an ID card of a woman. So this organization has gone ahead and taken it under their grievance redressal committee, which is also as good as the IC committee. So that can be done. Sorry.
Also, to add on to that, Smita, it depends on the workplace policies with respect to the queer community in general. So if the workplace policies do allow a grievance redressal forum for such employees who identify from the community, it doesn't stop a redressal forum to take on from the POSH Act itself. So, yeah.
Yeah, thank you. So what Ajay is saying that, there are redressal committees and they can use the similar methodologies, similar directives laid down by the law and operate. And there are organizations.
Just add one more thing. That is, for example, say if we take a person who is a lesbian or a bisexual, but biologically that person is a woman. So automatically this can easily apply. That might be her sexual preference, but that has got nothing to be with her to be a woman or a man. So for that limited purpose, it can definitely apply.
Yeah, thank you,
And to add to this, many organizations prefer, just like Ajay said, to have a gender neutral policy. Now, that's not the provision under the law. The provision under the law is a specific women-centric act. But a lot of organizations have included other genders and want to make it gender neutral, particularly multinationals, because that is what is applicable in their parent organization, and they want to have the same culture here. So that is an option that you have, that you can have a gender neutral policy, but all other provisions for example, 50% being women in the committee, all that needs to be followed strictly as per the Indian laws, but you can extend it to the extent of the genders. So that's, and it's also, it's quite common nowadays that you get, the harassment can happen of any gender, not just the female gender. Thank you.
Thank you. Thank you, Ganga. Thank you for that,
I-
because that's a pull and push all the time.
I have a question on the gender neutral. Can I raise it now?
Yes, Anuradha, go ahead.
Yeah, so Ganda, a point well made that many organizations are going for the gender neutral policy. My question is, does the IC need a separate training in order to deal with anything beyond an aggrieved woman who comes as a complainant? Because there are different laws under which the LGBTQ community are governed, and there are different nuances. It's a lot of behavior involved. So is the existing training that the IC have gone through sufficient? Or
I feel that if you already have a gender neutral policy, your training would be curated to address all genders, A. B, if it does happen, you might need an expert on board for that particular inquiry. So it is possible to get in an expert for specific inquiries as long as you follow, NDAs and all of that. But you get an expert on the committee if it is an issue that is not of the binary.
got it. Thank you.
Yeah, I think just adding to what Gandha mentioned, see, inclusive language is also important. Unfortunately, we all are brought up in a particular scenario where we are taught only about binary folks, right? And this is a very, very different subject. Sometimes we could get insensitive. So sensitization training is important. What kind of language to be used, even body language, some people don't even make an eye contact if they get to know that the person is from a different community, So all these things are important. So that sensitization training of being sensitive or handpicking your IC members who are sensitive, credible is important, Anuradha. So I think there has to be some level of thinking on when we are creating that committee.
Sure. Thank you, Smita.
Thank you, Anuradha. I think there are many questions I'm not able to, if anybody has, because we are almost timed up. If anybody has one last quick question, then we could wind off. We'll try and respond to it. We'll download the questions and see if we could respond to it separately. All right. I think
Sorry, Smita. I have one question. This is Shelly. I am a manager, people management from ISTM. I'm also part of IC committee here. So I have one question. For example, for the complainant and for the person, for the defendant, basically against whom the complaint has been made, do we share the report copies also, like what all the proceedings has been, and then we mention the witnesses' comments as well? So how do we put that in the report so that the witness is not, identities? Do we write like witness 1, witness 2, witness 3, or do we write like, how do we put that in the report to avoid to maintain the confidentiality?
So Shelly, I'm going to take this question because it's really my favorite question. I get these requests saying that we do not want to share the report, or we do not want to share the attachments with the parties. First of all, we should know that it's their right. Both the parties, complainant and respondent, it's their right to get the entire report and all the statements that each of them have shared. So if complainant has produced anything, it has to go to the respondent. If respondent has produced something, it has to go to the complainant. The witness statement should be available with both the parties because they have to prepare the defense accordingly. Now, when we are taking witness statement, we have to ask the witness if they are comfortable to share their names. Our case is stronger if the witnesses share their names. But there could be hostile witnesses. In such scenario, we redact their names. And as you said, we call them witness 1, witness 2, witness 3. And we don't only redact their names, we also redact anything that is giving away their identity. There are times when we have redacted their pronouns also. He said this or she said this. We've done that. Or he reports to this person. That also we have redacted because if it's the only one reportee, we'll get to know who it is, right? So we
Mm.
have to be sensitive. We redact it, literally, highlight it with a black marker, and we send it. So these are some things that we do.
Okay. Yeah. Thank you so much. Thank you, Smita. It clarifies my question.
Thank
I
you.
have a question if you guys have time.
Himani, okay, just last and then we close. I'm really sorry, but we should be mindful of the
Yeah,
time.
I'll be quick. I've already put in my question in the chat box, but I guess with the number of questions there, but I still wanted the answer. This is related to if the respondent leaves a particular organization and joins the other one. Okay, so now there is this background or reference check where obviously the company A doesn't divulge any kind of information except that there was a misconduct. Now the respondent is not happy with the proceedings of the IC in the previous organization and decides to take up the case to the High Court. So obviously that confidentiality issue is like all waived off because now it is all in front of the media and public, right? So
Yes.
what is the kind of conduct expected from organization A? That I understand that they have to support the respondent or complainant, whoever chooses to, go to the High Court. But what about company B? They were told that it was a misconduct case, and suddenly they are in, this kind of soup where one of their employees actually handling a sexual harassment case. So what ideally should be their conduct and behavior towards this particular person?
I have a point on that. Specifically, if it is wrongful termination. So if the employee of company A has been wrongfully terminated, then and if the person feels, if this employee feels, the respondent, it's a wrongful termination, they do have 2 years to file a case with the specific civil court of judicature and then file a case against the company A. Now, with respect to how the company B should respond or react, they can only sort of fall back to the earlier reply given by the company A in terms of their own reference check. There's certainly no legal, foundation on company B with respect to so the company B has to go with their workplace policies of how to, in terms of conduct or misconduct of their present employees. There's not much that the company B can do in this sense.
But
Because
Ajay,
then the company
his image earlier is actually being tarnished in this company also. I mean, people would start talking about this person, and so how does the organization handle such a situation?
Yeah, but then sorry,
Ajay, go ahead.
Yeah, but then the company A themselves have not disclosed the sexual harassment misconduct, right? So then the company is also to blame in some way if the question was not asked. I mean, there is some kind of non-disclosure by the company A itself. Now, when this misconduct has been disclosed at a different workplace in company B, then it becomes a matter of legal importance for that specific employee outside the company. It doesn't become a matter within the company or within their official capacity of whatever they are doing within the company B. I mean, that becomes their personal, professional matter outside the company B, is what I would say according to my limited understanding.
So Ajay, you're perfect. Ajay, you're perfect from legal aspect, what you're saying. But now I would want to add here the HR or the organization's perspective. Yeah. Now, what has happened is this is a situation where there is an employee where when we did a BGV, it was almost a clean BGV. Background verification was clean. But now over a period of time, the BGV seems like incorrect. Okay. Now it is, Himani, for the organization to take a call. Now, organizations say that because it was a sexual conduct and it's an appeal, it's not proven. I mean, it was proven in the lower court, that is IC, but now it is in the appeal stage. Do they want to do anything about his candidature at this point of time or wait for the court hearing to come? Okay, that is one. Second, do they want to punish this person again for a conduct which he has done and got punishment earlier? Is there a repeat punishment? That could be another point of discussion for them. Third, if the IC report, I mean, this organization can now approach this, B organization can approach A organization and ask them that you would have wrongfully terminated this person. Now we get to know that he was terminated for sexual harassment thing. Can you share some details with us? Okay, there is no stopping of asking. Now it is for organization A to tell us whether they will share or not share. They have the right to say, no, we will not share. They have a right to say that this is what it is. Now, depending on what report, if they don't get anything, then it's business as usual. If they get something, then again, the decision is on the company B to take a call. Okay, do they want to go ahead with that outcome?
Just a last point adding on to what you were saying, Smita. It should be noted that the IC as a institute, as a group, it's not handling criminal proceedings. So it's a civil, it's a civil proceeding. It's not a criminal proceeding one, and therefore, whenever even the company B or company A, the most that they can do is only terminate the employee at the last end. There's nothing else that they can do. So they can just terminate their contract or the appointment. There's nothing beyond, depending on then the complainant itself going to the court outside the company. So IC proceedings are all, they are not criminal proceedings. Just adding that. Yeah.
Yeah, thank you. I think that's important. Himani, I hope you have got a fair view. And I think we have overstepped 11 minutes more than what
Yes,
we have.
thank you so much, everyone. Thank you so much.
Thank you. And I think this bunch was so exciting to have a discussion with. I thoroughly enjoyed this conversation. Any last words from Ajay, Pinak, Gandha? I hope I've not lost them.
No, we are still there.
Yeah, thank you, Smita. It was wonderful. And I really don't have closing remarks, but I think I'm going to go back to my statement that confidentiality is about culture. And we have to build it in our culture to respect our colleagues and to respect a subject as sensitive as this. And the law is just what the law is. It can be interpreted in various ways, but our morality is primary, and I think we need to work on that first.
Absolutely, so well said.
There can be no exception to values.
Yes.
Absolutely. I mean, we've just tried to making boundaries, but if people are not respecting those boundaries, then it doesn't make sense at all. Lovely. Ajay, anything from you?
Yeah, just this is for information's sake for all the participants. There are 3 case laws specifically that usually talk about confidentiality coming from Madhya Pradesh High Court. One is from Delhi High Court and the other is from Bombay High Court. You might look, I did not have the time to go into that, but they are Pavan Kumar versus JC Chaturvedi 2011, Pradeep Kumar Saxena versus Institute of Applied Medical Science and Research of 2016, and Dr. M.N. Bhartiya versus Indian Council of Medical Research 2018. These specific case laws are where you can interpret where the high courts themselves have said how crucial confidentiality is to the IC proceedings. So for information's sake. Yeah.
Ajay, that's a great research, and I request if you could share it with us. What we'll do is create a small blog around it and share it with this group here.
Yeah? Surely. Yeah. Thank you so much. Yeah.
Thank you so much.
Thank you, Smita. It was a wonderful session. Thank you.
Thank you, all of you.
Thank you.
Each one of you.
Thank you. Yeah.
Thank you.
Everybody, thank you.
Very nice.